Good morning and good evening to everyone. I'm joining you from the lands of the Wurundjeri people of the Kulin Nations here in Melbourne, Australia, and I acknowledge the care for country, including sea country, by Australia's First Peoples over millennia. Thank you to the American Society of International Law Interest Group on the Law of the Sea for hosting today's webinar. A particular thanks to Professor Bimal Patel and Dr. Louis Nengue for this kind invitation. In the context of today's topic of the Evolving Climate Jurisprudence under the UN Convention on the Law of the Sea, or UNCLOS, I wish to focus on the International Court of Justice's advisory opinion on climate obligations delivered in July, which, as is well known, followed and gave great weight to the International Tribunal for the Law of the Sea in its advisory opinion of 2024. While the request to ITLOS focused on the interpretation of UNCLOS, the request to the ICJ was broader. Both opinions have profound consequences for the obligations of states with respect to climate change, including through application and interpretation of UNCLOS as applied within the corpus of public international law. And I'm going to explain why I have this grouping of states in my background slide. In the next 20 or so minutes, I wish to address how the advisory nature of the opinions, though not strictly binding, affect all states, parties and non-parties to prominent treaties, such as the Paris Agreement and UNCLOS, the relationship between UNCLOS, the Paris Agreement, and other rules and principles, including customary international law, and the interpretative techniques and implications of what I will show to be systemic reasoning in the advisory opinions. My slides are based on data visualizations that I have developed with two colleagues at the University of Melbourne, Dr. Stanislav Radovsky and Dr. Dan Parker, who as designers helped map relationships which we as lawyers are more used to engaging with textually. So what is this strange background behind me? This is not the climate system made up of the atmosphere, the biosphere, the geosphere, and the hydrosphere, among other components. Instead, it represents the system of public international law, which, at the risk of stating the obvious, is made up of sovereign states, all 198 entities with treaty-making capacities here featured on this slide. These states, through a majority resolution at the UN General Assembly, request an advisory opinion from the primary judicial organ of the UN, the ICJ, on the content of legal obligations in respect of climate change and the legal consequences for any breaches of those obligations. The General Assembly and the smaller group of states within the Commission of Small Island States who requested the advisory opinion from ITLOS are parties to a vast range of treaties, many of which relate to climate obligations and the oceans. There are relevant treaties alongside UNCLOS which include the climate regime comprising the Paris Agreement, the UNFCCC and the Kyoto Protocol, multilateral environment agreements, such as the Convention on Biological Diversity and the UN Desertification Convention, and human rights law, such as the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. When considering how these regimes interact, it is important to remember that they have mostly overlapping membership, though not always identical. A good example is the big country of the United States, which out of the 8 treaties that I've mentioned is party to 4, Paris, the UNFCCC, the Desertification Convention, and the ICCPR. This contrasts with the tiny country of Timor-Leste, neighbouring Australia, which is party to all 8 treaties I've mentioned. In the language of generally accepted rules and standards, a phrase familiar to us from UNCLOS Article 211, these 8 treaties are generally accepted rather than universally accepted. In contrast, all of these states are bound by customary international law where there is evidence of a general practice accepted as law, opinio juris, which impacts on the interpretation of treaties, as we will see. Visualizing the states in a geographical map is also useful in conveying the way in which the advisory opinions affect the obligations of states. Both the ICJ and UNCLOS advisory opinions constitute legal advice to the entities that requested the advice, the General Assembly of the UN in the ICJ's case. Although non-binding, unlike rulings in contentious cases, which bind the disputing parties, advisory opinions are an authoritative interpretation of the relevant rules. In this map, the countries in blue have signed the optional clause indicating their consent to the ICJ's contentious jurisdiction. In pink are states that have not signed the optional clause, though of course they may come to the court if they choose the ICJ as part of the procedure of Part 15 of UNCLOS, as one of many examples. I want to move now to the state activities that adversely affect the climate system, highlighting the importance of activities on both land and sea. In this visualization, the sizes of circles indicate how much countries spent per capita on subsidies for their oil, coal or gas sectors in 2021. Why is this relevant to obligations to protect the climate system, which under the Paris Agreement relate to territorial emissions, or under UNCLOS relate to pollution and the protection and preservation of the marine environment? The ICJ led from the scientific realities of the climate system to better understand the scope of relevant activities, a crucial jurisprudential move that had also been taken by UNCLOS. The ICJ considered that the scope of relevant activities adversely affecting the climate system is not limited to conduct that directly results in greenhouse gas emissions, the burning of oil, coal or gas for energy, transport or heating in the territory of a state, but instead comprises all actions or emissions of states which result in the climate system being adversely affected by anthropogenic greenhouse gas emissions. Thus, activities such as ongoing production, licensing and subsidization of fossil fuels is included. This framing of scope of activities by the ICJ helps us understand the earlier advice of UNCLOS regarding obligations of states to prevent, reduce and control pollution, which is interpreted to include greenhouse gas emissions, and the clear provision in UNCLOS that states parties have a specific obligation regarding marine pollution, including from land-based sources. The ICJ and UNCLOS's approach to land and sea activities gives a more expansive and more realistic account of duties to protect the climate system. This takes me to the related point: did the ICJ apply only the Paris Agreement or other rules and principles? In this visual, I've included details for 8 key treaties, though more were addressed by the ICJ. So Paris, the UNFCCC, Kyoto, the CBD, Desertification Convention, UNCLOS, the International Covenant on Economic, Social, Cultural Rights, and the ICCPR. And I've noted their level of ratifications. As occurred in the UNCLOS proceedings, some states argued that the Paris Agreement was the only relevant source of obligation, that it had a special status as lex specialis that displaced other rules. The ICJ disagreed. Like UNCLOS, it did not consider the Paris Agreement was lex specialis with respect to climate obligations. The ICJ assessed the climate change treaties alongside other rules and principles, including the law of the sea, environmental treaties, human rights, and a customary duty to prevent significant harm to the environment. All these sources contain obligations to protect the climate system. You can see by the dominant color blue, the majority of states here have ratified all 8 of these treaties, which gets to the point I mentioned earlier about generally accepted rules. Breaking this down by region, it can be seen that most states have ratified all 8 of the selected treaties in each region except Oceania. The only state that has not ratified the Paris Agreement, there is Iran and Yemen and Libya, and the US has indicated it will withdraw. I should mention too that of those states, Iran and Libya have also not ratified UNCLOS, and nor of course has the United States, among other countries coloured in pink or purple here. That said, many provisions of UNCLOS are recognised as codifying customary international law. As we will see, treaty provisions from Paris and the other treaties are also now seen as representing customary international law with at least some overlap in obligations. States must fulfill their stringent due diligence obligations, especially in situations in which activities are mostly carried out by private persons or entities in language that mirrors the words of ITLOS. States must also ensure their nationally determined contributions, or NDCs, are adequate, reflective of best efforts, and capable of achieving the temperature goal of limiting global warming to 1.5 degrees above pre-industrial levels when assessed together. Once again, the map view reinforces the way in which customary international law applies to all states. The ICJ was of the view that as part of their obligations to protect the climate system under customary international law, states must act with due diligence and prevent activities carried out within their jurisdictional control from causing significant harm to the climate system. This standard of due diligence for preventing significant harm is stringent. Here, once again, ITLOS's phrasing applies. It includes effective regulations to reduce greenhouse gas emissions and a heightened degree of vigilance by the state. If a state is complying in full and in good faith with the climate change treaties, and recall that it is these obligations as robustly interpreted by the court, it is likely to be substantially complying with its customary duties, although more may be required. This observation by the ICJ is similar conceptually to ITLOS's earlier understanding of the relationship between Paris and UNCLOS, when it said mere compliance with the Paris Agreement does not satisfy the obligation to take the necessary measures under UNCLOS. I want to briefly mention the question of common but differentiated responsibilities, bearing in mind that this principle is absent from the text of UNCLOS. Do the customary obligations with respect to climate apply equally to all states? In this slide, we've tracked each state's value in the Human Development Index, reinforcing the point that states are not equal in their economic situation and capabilities in adapting to climate change. One could also visualize differently sized circles to track differences in cumulative emissions, which I'll display in a moment. Alternatively, rather than these circles, it might be better to emphasize the facts noted by today's co-chairs, that approximately 3.3 to 3.6 billion people live in contexts that are highly vulnerable to climate change. The advisory opinion of the Inter-American Court of Human Rights emphasized that climate change exacerbates inequality and poverty, something that was taken up by the ICJ, including in the separate opinion of Judge Charlesworth. The ICJ did not focus on particular vulnerable countries or groups of countries, but it did pronounce on differentiated obligations in ways that are important for the evolving UNCLOS jurisprudence. As we know, the climate treaties endorse the concept of CBDR-RC, but UNCLOS does not. The ICJ held that obligations under the climate treaties and customary international law apply to all states, but well-developed economies have more capabilities and resources and thus more means at their disposal. Developed states, as indicated, for example, by a bigger value of the Human Development Index, or a bigger circle, must take more demanding measures. But as states develop economically and their capacity increases, so too do their requirements of diligence. This flexibility was also offered by UNCLOS when it observed that the scope of measures under UNCLOS Article 194, in particular to reduce anthropogenic greenhouse gas emissions causing marine pollution, may differentiate between developed states and developing states. It also noted the obligation of assistance contained in Articles 202 and 203, which show that states with lesser capabilities need assistance from states that are better placed in order to meet their environmental responsibilities. UNCLOS drew on these provisions, together with provisions relating to vulnerability in the UNFCCC and the Paris Agreement, and the General Assembly's annual resolution on oceans and the law of the sea, to show that financial assistance is due to developing states to assist in the protection and preservation of the marine environment and the prevention, reduction and control of marine pollution. Let us move to other obligations with respect to climate change in the law of the sea and other treaties, including environment treaties and human rights law, obviously deserving a webinar of their own. But here the sizes of the circle corresponds to relative population size, and the colours remind us about treaty ratifications of those selected 8 treaties I mentioned earlier. The ICJ noted that though the express aims of these treaties are different, they share overarching motivations relating to the protection of the climate system. For example, parties to UNCLOS must protect and preserve the marine environment and cooperate, including in finding equitable solutions for populations displaced by sea level rise. This topic is explored in today's webinar, so I won't address it further now, but it proved an important way to integrate the work of the International Law Commission. I don't have time to discuss other aspects of the opinion, but the ICJ deftly demonstrated that climate obligations stem from other regimes besides the climate regime. And indeed, in regards to the ocean, the court was careful to mention MARPOL and its Annex 6, the role of the IMO in regulating greenhouse gas emitting activities from shipping, and the BBNJ agreement. This again displays the willingness of the ICJ to provide systemic understanding of climate obligations which flow not only from each separate treaty, but from an interpretive understanding of the connections between the treaties. To delve into the Vienna Convention on the Law of Treaties for a moment, Judge Tladi noted that the customary duties regarding prevention of harm as relevant rules of international law informed an interpretation of the robust requirements of NDCs under Paris as set out by Vienna Convention Article 31.3c. UNCLOS had itself had endorsed Article 31.3c in general terms in its advisory opinion, though arguably both opinions were propelled more by Article 31.1 implicitly. And of course, we had the ICJ's views on subsequent practice for COP decisions under Vienna Convention Article 31.3a, which again followed earlier work of the International Law Commission. The ICJ's observation of the customary duty to cooperate, which informed its discussion on the legal character of the duty to address sea level rise, is another example of its attempt to bring coherence to the corpus of public international law in respect of climate change. Let me spend the remaining few minutes on the legal consequences arising from a breach of these obligations, something that was specifically requested of the ICJ as contrasted with the earlier UNCLOS request. In this mapping, the size of the circle corresponds to the cumulative greenhouse gas emissions from each country from 1850 to 2023. And of course, there are other ways to date this data, which the ICJ implicitly acknowledges when it declined to engage with temporal issues, noting that the discussion would be more appropriate in concreto assessments of responsibilities of particular states. Instead, the ICJ gives a general and abstract overview of the legal consequences arising from a breach of the obligations it has identified. States are responsible for a breach of these duties For example, high emitting states may be required to provide reparations, including compensation to injured states. Small island developing states are among the most vulnerable to climate change, despite contributing the least to global emissions, as I mentioned earlier. And because of the common interest in protecting the global environmental commons, any state can pursue a claim involving responsibility for breach, i.e. the underlying obligations have an erga omnes character, a very important finding for ocean equity. Every region contains or is neighbour to small island developing states, marked here in the blue. The ICJ observed that remedies for breaches could include reconstructing damaged or destroyed infrastructure and restoring ecosystems and biodiversity. For Judge Bandari and Judge Orescu, remedies could cover sea level rise and maritime entitlements. Moreover, Judge Cleveland emphasised states' duties to protect carbon sinks, including wetlands and ocean areas. Consistently with UNCLOS's views on financial assistance, she considered that a state with greater capacities has a duty to provide assistance to a state with limited resources in the protection of these climate sinks. This evolving jurisprudence is likely to influence regional courts and tribunals. A last slide, and let me group by optional clause again. As a whole, states and their populations around the world, including states parties to UNCLOS, now have greater legal certainty about the obligations of states in respect of climate change and the legal consequences if their actions fall short of what is required. While we may group these states as those exposed to litigation at the ICJ through acceptance of the optional clause, this is an interesting but incomplete picture. As we know, obligations exist under UNCLOS and contentious cases under UNCLOS proceed in a different way. Moreover, both the ICJ and the UNCLOS advisory opinions contain interpretations that will be useful for regional and domestic contentious cases. And finally, I acknowledge here the sources of the data used for the visualization, bearing in mind the experimental nature of our efforts and hoping that more analysis and different visualizations will follow as the systemic integration of treaty and customary obligations leads to changed behaviour and activities of the central subjects of international law, the states themselves. This concludes my short presentation for the American Society of International Law about the evolving climate jurisprudence under UNCLOS and other treaties and customary international law. It's great to situate my comments alongside my fellow panelists' reflections at the webinar today. Thank you to the organisers and attendees. Goodbye.